I'm Spencer Mazyck, and joining me now is Joan Lukey. She is a partner at Ropes Gray who recently obtained a $51 million award on behalf of her client, best-selling crime novelist Patricia Cornwell, in a highly publicized lawsuit accusing the author's accounting and business management firm of mismanaging her finances. Welcome, Joan. Thank you for joining us today.
My pleasure.
So, Joan, I have to say this case sounds like it's plucked right from the pages of one of Patricia Cornwell's crime novels. But before we get to the details, can you tell us, how did you come to represent the author and her partner in this case?
Well, I've been representing Patricia Cornwell since about 2006, beginning with an action that she brought against a fellow author who had falsely accused her of plagiarism. So as the years went by and she began to have issues with her business management firm, she came to see me as the attorney who represented her locally on litigation matters.
When the couple filed this complaint back in 2009, what was their financial status? How did they suspect that their finances were being mismanaged?
Well, what had occurred was this. In early 2005, the management firm with whom Patricia had been working merged into a larger firm. The larger firm provided her with a financial statement at my request in or about July of 2009, which showed that despite more than 4.5 years of very, very high income earnings, her net worth was approximately the same as it had been when she started with them more than 4.5 years earlier. As a result, she terminated their services, requested her files, and began searching through them to try to understand what had gone wrong.
Well, and Cornwall asserted claims of negligence, breach of fiduciary duty, breach of contract. But what were some of the specific allegations against her former financial managers?
Well, there were a couple of items that were larger than others. Perhaps the largest single item in the category of contractor breach of negligence, as opposed to breach of fiduciary duty, was a claim that she had missed a book deadline in her Scarpetta series in its entirety, that is, lost 1 year. Because this is a serial, if you will, systematic annual publication. The franchise is every year in the fall at this point in time. She just lost the year. That meant a loss of $12 million in domestic revenues and $4 million in international revenues. And it was her contention, which the jury apparently accepted, that because of their inability to handle her real estate needs appropriately, she was basically left with no place to write for the last several months before her deadline, and hence, for the only time in her career, she missed the deadline. So that was the single largest item. And
the defense argued that the losses were due in part to the economic downturn, and that Cornwall insisted upon living in the lap of luxury with sports cars, helicopters, jets, and multi-million-dollar homes had your client lived an overly lavish lifestyle.
No, not overly lavish for the income she was earning. Let's remember, this was her money and it was earned income. She had the right to spend it as she wished and to live as she wished. As she herself has put it, yes, she lived large, but did she live lavishly relative to her income? She did not.
Joan, were you at all concerned about the Boston jurors having a hard time relating or identifying with her, because she certainly didn't get much sympathy from the press?
Well, it depended on which press you were reading. She didn't get much press from the sympathy from the New York Post or the New York Press, where the financial firm was located. The coverage in Boston, where the trial was held in federal court, was much more balanced and much more favorable as a result. You're always concerned when you have a wealthy client that jurors will not relate. On the other hand, particularly perhaps in these days, jurors are very, very aware of possible mismanagement on the part of financial firms, and it was her money that they were managing.
When speaking of the jury, I heard that they seemed to be dropping like flies at one point, so much so that you actually you had to suspend the trial. So what happened?
Well, we, of course, were trying this in the middle of flu season in Boston. The case started in January and ran through most of February. That's the worst possible time of year, and yes, we dropped very quickly from 12 down to 8, and of course 6 is the permissible minimum. So when one of the remaining 8 developed the flu, we suspended for 2 days to allow her to get better so that we wouldn't lose another juror.
Then the trial took a total of 7 weeks, with the jury rendering an award of $50.9 million in favor of your client. And Cornwall has been quoted as saying that she was shocked by the outcome. Why? Why do you think that is?
Well, I think she was not shocked by the outcome so much as perhaps by the dollar amount. In my closing argument, I had asked the jury for approximately $25 to $26 million based on specific factors. They, of course, also had the right to award punitive damages for the breach of fiduciary duty under New York law, and New York law applied on the common law counts. So I think when she referred to her level of surprise, it was that the jury awarded the $26.4 million for breach of fiduciary duty and then awarded the same amount again for punitive damages.
And isn't it true that your clients, do they plan to donate a portion of the award to benefit mental health research?
That is absolutely true. As you probably know, Dr. Gruber, Stacy Gruber, Ms. Cornwell's spouse, is a neuroscientist at McLean Hospital. And the intent is, in fact, to donate a portion of the recovery, once it is actually received, to McLean Hospital for mental health research.
So, Joan, as you know, trials can sometimes make public those things that we wish were not. And for the novelist, it came to light that she is somewhat paranoid about some of her past relationships and that she even had an enemies list. Is that true?
No, it is not true, actually. And that was not part of the evidence that was in front of the jury. What happened was the defendants chose to file publicly, that is on the PACER system, the entire file that they had turned over in a Department of Justice proceedings that had resulted in Mr. Snapper being convicted of a felony in connection with campaign contributions. And in that file, buried within it, was a confidential email. We did not know they were filing this, that related to her request to her security folks to keep an eye out at some very public book signings for certain individuals who might bear a grudge. It was by no means an enemies list. It was not in front of the jury, and it was not an exhibit. It was something that the New York Post came upon on the public filings, and we don't know to this day whether it was suggested to them that they look for that document, but was one page in the middle of a very large stack. It did not say enemies anywhere on it, and it was not paranoid. It was a request for security to be careful at certain public events in certain geographic areas.
When Joan, the list included names of former friends and former employees, right?
It was, well, I recall that there was a list. The list related, wasn't a list actually, the summary related to another author with whom there had been some issues, and I believe there was at least one former employee whom there was a concern as to whether the individual carried a grudge.
So where do things go from here? Do you expect the defendants to appeal this decision?
We do expect that there will be an appeal. At the moment, the matter is still pending before the trial court on the so-called 93A claim, which is a consumer protection claim pursuant to which the judge has the authority to award more damages, but more likely, if he so chooses, to award Ms. Cornwell, Dr. Gruber, their attorney's fees. When that is done, the judgment will enter, and at that point, the defendants will have the right to file several motions, for example, for a remitter to reduce the amount of the verdict, and then it will go up on appeal. Recall, the jury verdict is one step in the process. There are several legal issues that the court will have to resolve before we actually know whether the dollar amount due and owing is more or less than that returned by the jury.
And finally, Joan, I joked earlier that the details of this case could be a part of a novel, but might it? Could we see this case, this situation, make its way into a storyline in Cornwell's next book?
Ms. Cornwell has herself indicated that there is going to be a theme in her next book that relates to a financial institution. She certainly is not claiming that it tracks this trial or these events directly or completely, but that there is a financial institution involved in the next book, the one that will come out next fall.
And I'm sure that many folks will look for similarities in that book here with this particular case. I want to say thanks so much for joining us today to talk about it. Fascinating story, Joan.
Thank you very much. My pleasure.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us today. Bye, everybody.